Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Thank you. Good morning and welcome to the June 12th sitting of the Massachusetts Appeals Court. We are going to be hearing the case of Boston Redevelopment Authority versus Boston Private Bank and Trust Company and others, 219 P1253. I am Justice Maldonado, and I am fortunate, and so are you, to be joined by Justices Wendlandt and Justice Hand, and we are your panel for this morning. As I indicated earlier, 15 minutes for each side, no opportunity for rebuttal. If you've done your complete argument before the 15 minutes are up, there's no penalty for sitting or ending early. If, however, you have not finished all your arguments and the time has run, understand that the panel has reviewed all the submissions. We've familiarized ourselves with the issues, and we will certainly give every issue its full attention. With that said, I will have Mr. Collier begin.
Justices, good morning. This case arises from the foreclosure-related conveyance of a Boston Redevelopment Authority publicly subsidized wheelchair-accessible residence in Charlestown, Massachusetts. And more importantly, this case involves the public interest in the affordability covenants which make the construction of affordable housing possible throughout the Commonwealth. Those affordability interests in this case and in other cases are secured by two record instruments: a second mortgage in favor of the subsidizing authority, here the Boston Redevelopment Authority, and a deed covenant that runs with the land that restricts the subsequent conveyance of a moderate income subsidized unit by limiting the price at which it can be sold to the maximum resale price, which would be affordable by a moderate income family, by limiting who can purchase it to only income qualified moderate income families, and by limiting the purchaser to someone who intends to live in the unit.
Can I ask you a question, counsel? Yes. So you say it runs with the land, but it doesn't run with the land without condition. Is that correct?
It does not run with the land without condition. That's right, Your Honor.
And the question is, one of the conditions at least is that the mortgagee may hold a mortgage or security interest in the premises and may acquire title to the premises by foreclosure.
Exactly, Your Honor. That provision makes it possible for purchasers to be able to buy these units so that the mortgaging bank can recover its funds. However, that exception applies only where the foreclosing bank is compelled by the absence of other purchasers to be the prevailing bidder at a public auction. That is, do
you agree that a foreclosure is complete at the time of the auction sale?
No, Your Honor.
You don't.
If by at the time of the auction sale, you mean at the time the memorandum of sale is signed?
It's signed, yes, and executed.
There's a difference between signed and executed, Your Honor. Signed under the case law is the signing at the document. Executed is the actual purchase pursuant to the contract. No court has ever held.
Stop you, counsel. How do you then distinguish the cases cited by your brothers, Outpost and Williams, which specifically say that the sale occurs at the signing of the memorandum of sale?
In every one of those cases, the memorandum of sale was actually performed, quote, executed in the language of the decisions.
Yes, was ultimately actually performed, but the cases stand for the proposition that at the signing of that memorandum, the sale has occurred. Because in each of those cases, the mortgagor was trying to, to intervene and say, I can now redeem because I can now pay, and that those courts held, no, you can no longer do that because the sale is complete at the signing of the memorandum.
Every one of those cases was decided pursuant to the statutes that governing the extinction of the right to redeem.
Right.
And every one of those cases involved a circumstance where the memorandum of sale was actually executed. And finally, and most importantly,
and where in
none
those
of those
cases do you find the proposition that the actual sale occurred relevant to the decision, relevant to that decision?
None of those cases.
To me, that at least in the Outpost case, the only relevant issue was whether the memorandum of sale was signed and when it was signed.
Your Honor, in the Outpost case, what was at issue was when the sale is completed and the mortgagor who took out the loan tries to redeem between the signing of the contract and the actual conveyance of the deed, that right is gone. That makes perfect sense under standard contractual law, Your Honor. It makes no sense where the contract is repudiated by the purchaser and breached by the bank. And more importantly, Your Honor, if you look at each of those cases, every single one of them starts with the observation that if everything else about the sale is proper, in everything else about the sale is normal and regular, then the signing of that document extinguishes the right. Brown says unless there was some defect in the proceeding. White versus Mozzarella says if a foreclosure sale is fairly conducted and there is no defect in the proceedings. And Outpost.
So I guess that brings us to the nub of your argument. What is the defect in the proceedings that you're identifying here?
There are three of them, Your Honor.
Okay.
The first one and the most important one is that 18321 allows the conveyance of a property by non-judicial foreclosure if and only if the mortgagee conveys the property to a prevailing bidder at a public auction. The Supreme Judicial Court has held 50 times over 200 years that if the sale is to anyone other than a prevailing bidder at a public auction, the sale is void and the property is returned to the pre-foreclosure title status. Here, there is no question but that Boston Private Bank was not a prevailing bidder at a public auction, and more importantly, that the trustee who subsequently was sold the property purportedly pursuant to that auction never appeared at the auction, never bid at the auction, had no interest at the auction, and bought it at a private sale outside the public auction process. Every single decision by the Supreme Judicial Court has held that that's a void foreclosure and that the property is restored to the pre-foreclosure status. More importantly, Your Honor, no court has ever held that a contract of sale, which is what a more memorandum of sale is, which is repudiated by the purchaser and breached by the seller, affects any third-party rights. In fact, there is no decision in contract or anywhere else in any decisional law that says a repudiated agreement has any effect on the rights of independent third parties. And finally, Your Honor, the defects in the sale process are exactly those identified by the first judge who heard this case and the first judge who heard the motion to dismiss, Judge Davis, who said they clearly allege in the complaint plausible violations of the power of sale by Boston Private Bank and by the trustee, that their conveyance agreement to wash the property of the affordability restrictions plausibly alleges a breach of the duty of fair dealing and plausibly alleges a breach of 183 Section 21, which required that it be conveyed to a purchaser at a public auction. Your Honor, no case has ever held that anyone
I'm
other.
sorry, I lost track of your three violations. It was 183.21.
There's 183.21. There's the conclusion that holding that a memorandum of sale extinguishes the rights of independent third parties when it's never executed and when it is repudiated and breached. And finally, the third violation is that where the property is conveyed to anyone in order to extinguish the affordability covenants, it breaches the private bank's duty of good faith and fair dealing, which could render the conveyance void.
I'm
And
sorry, so where is it that the private bank has a duty of fair dealing to your client?
as Judge Davis held, and as the decisional
Well, I
law,
mean, regardless of what Judge Davis held, tell me what the law says, yeah.
what the law says is that the foreclosing bank is the trustee for all of those holding subordinate interests, including lien holders and those enforcing restrictive covenants.
And so
And
your position is that the bank, it has a duty to sell to the next highest bidder, which would be a lesser amount, in order to what?
Your Honor, they
I'm
have
confused by that because I thought your argument was that they needed to sell to the next highest bidder.
my
which
argument is
rendered less money to the homeowner. I don't know how to square those two. The bank it seems to me that the mortgagee has a duty to the mortgagor to get the highest price.
Your Honor, particularly where there's a restrictive covenant on the deed and a mortgage, the mortgagor is not entitled to receive the highest price. The mortgagor here is by law entitled only to receive the maximum resale price, which is $240,000. There is no
that doesn't really make sense to me, because if that were true, it would be easy enough to write a covenant that wasn't voided once title vested in the bank.
Your Honor, if you wrote a
Seems to me
covenant,
there was a policy decision to allow a bank that's a mortgagee to acquire title and thereby void the covenant. I think that's exactly what it says.
it says to acquire title by foreclosure, Your Honor, and foreclosure is clearly defined by 183 Section 21 as meaning the conveyance of a property to the prevailing bidder at a public auction. That's the only conveyance that the exception to the covenant permits. That is, the bank can't just deed the property to anyone it wants. It must comply with the power of sale requirements regardless of any other provisions in the documents. No bank can foreclose a property in violation of the power of sale. And here the bank undisputedly violated the power of sale by conveying the property to an entity other than a purchaser at a public auction. As the Attorney General's brief points out, no one other than a prevailing bidder at a public auction can acquire a foreclosed property by non-judicial foreclosure. That the case law is unanimous in that respect. And
okay, so can I ask a question? I just want to understand the practicality. If the bank had, if the highest bidder actually had not said, I'm gotten out of it, they would have had the property with the covenant still in effect. Is that what you're saying?
And the BRA notified the purchaser that they would enforce it against them. Yes, Your Honor.
Okay. If it went to the second highest bidder, if that person said, no, I don't want this, and the second highest bidder got it, the covenant would still be in effect as well?
It would, Your Honor. The covenant is in effect unless
the bank takes it under foreclosure. So if the bank had gone through all the highest bidders and no one was left, and then the bank took it, you're saying that would have been fine?
Dundas actually says the opposite. Dundas says that only if you announce what I would shorthand call the line of dissension at the time of the foreclosure auction can you go through the list. Here, the memorandum of sale did say we have the right to offer it to the second highest bidder, but no one below that. At that point, the bank was required to hold a second foreclosure auction, which is what Dundas says. The bank here would never be able to take the property to itself because it was the 44th highest bidder, and it never, at the time of the sale or any other time, announced that it could sell the property to the maker of the 44th highest bid. The Dundas decision of
in
the,
Dundas, is it though? I mean, that's not what Dundas holds. There's some language in Dundas to that effect, but that's not the focus of that decision, correct?
the Dundas decision, Your Honor, expressly holds that because they announced it orally at the time of the Dundas sale, it did not violate the power of sale to convey it to the second highest bidder. Clearly, the obverse, I guess, is true, which is that if they don't announce that as a condition of sale at the time of the sale, they can't convey it to subsequent bidders. And the bank here never announced at the time of sale or any other time that it was going to convey the property to the 44th highest bidder. And that ignores the fact, Your Honor, that the second highest bidder was never offered, the third highest bidder was never offered, the eighth highest bidder was never offered the property. Boston Private Bank simply got an offer from someone who was not a bidder at a public auction to buy the property from them, and decided that that was the most profitable and easiest way for the bank to dispose of the property. And they conveyed it to someone who never bid at public auction. The no harm, no foul argument, Your Honors, is the argument that the Supreme Judicial Court has rejected in every foreclosure case. That is, every mortgagee arguing that these people couldn't afford their mortgages and you shouldn't restore the title because there was no harm in whatever we did, starting with the Banyas, when they said, we almost have title and there's no harm to the borrower because the borrower can't pay the mortgage. The borrower didn't even show up in the case. I was appointed counsel to represent them. In that case, the SJC said it doesn't matter if there's a harm or a foul. None of that matters. If you didn't comply with the power of sale, the sale is void, period.
Okay.
No matter
Thank
what.
you. I think we have your argument and you're really over time now. So we'll hear from Attorney Riley.
Very well.
Thank you.
May it please the court. My name is Stephen Riley. I'm with the firm Fitch Law Partners here in Boston, and it is my privilege to appear this morning on behalf of Defendant Appellee, Boston Private Bank and Trust Company. Members of the panel, the Superior Court's entry of judgment on the pleadings in favor of Boston Private and against the BRA was entirely correct, and that judgment should now be affirmed here. As is set forth in Boston Private's brief, this appeal turns on the application of settled law to the unambiguous language of a terminable covenant that the BRA itself drafted. Now, each and every count of the BRA's second amended verified complaint is predicated on the allegation that Boston Private and the so-called Starikoff defendants somehow conspired in January of 2018 to manipulate the foreclosure sale process so that it resulted in termination of the affordable housing restriction on the Warren Street condominium unit. As a matter of law, though, that covenant, and in accordance with its own crystal clear terms, the covenant was automatically and properly, validly terminated back on December 6th, 2017, which is weeks before any of the supposedly improper conduct ever allegedly took place. And to distill Boston Private's argument to a single sentence, I would say there can be no conspiracy to extinguish a covenant that has already been validly terminated. And for that most basic reason, the judgment below.
So you're saying, what is the position that why it was validly terminated weeks before?
Because, Your Honor, Massachusetts is a title theory state. A mortgage, the reason it was terminated weeks before is, as Justice Wendlandt anticipated her question earlier, when Boston Private and the high bidder executed the memorandum of sale at the close of the foreclosure auction, the Gastovich Estate's equity of redemption was foreclosed. The law is clear on that point. The equity of redemption was foreclosed at that point. The SJC says in Bevelock, well, when the equity of redemption is foreclosed, the former mortgagee is vested with both the legal and equitable interest in the property. So as a matter of law, as soon as the memorandum of sale is signed, the Gastovich equity of redemption is foreclosed, Boston Private acquires, as a matter of law, fee simple title to the property. Under the covenant says, as soon as the mortgagee acquires title by foreclosure, the restrictions are extinguished. Title is acquired by foreclosure when the memorandum of sale is executed, and the covenant is extinguished at that moment.
Is there any impact on the fact that the deal wasn't consummated on the former homeowner's right of redemption? Does that have any impact?
I'm sorry, Your Honor, I couldn't, there was feedback. I couldn't hear your question.
My question is whether the fact that the that the original offer didn't ultimately result in a sale to that bidder, did the fact that there was a retraction of the bid influence the former homeowner's right of redemption? Did it
No, Your
reinforce
Honor.
their redemption?
No, Your Honor, it did not. The right of redemption was foreclosed with the execution of the memorandum of sale. The fact that Mr. Mikhail Starikov hesitated after being threatened by the BRA does not alter the fact that for those prior 30 days and continuing thereafter, Boston Private still had full, complete, undivided title to the property, fee simple title to the property. The right of redemption does not spring back into existence. Boston Private still has fee simple title and still has a duty of good faith and reasonable diligence to sell the property in a way that protects the mortgager's right to obtain whatever portion of the surplus the estate may be entitled to. But no, it does not affect the equity of redemption. And your question about a different bidder, it's critically important that we look at the allegations of the complaint. Mr. Collier argued that there was a conveyance to someone who didn't bid. The BRA's own complaint alleges that the Starikov defendants, so-called, are one and the same. That Mikhail Starikov, the father, assigned his bid to the son Fred, who then created the trust. And that Janet Blake is alleged in the complaint to be the nominee of Fred. So the property was sold to the nominee of the assignee of the high bidder for the amount of the high auction bid. That is what the execution of the power of sale requires. It was fully complied with here.
But if that's the case, they took it subject to the covenant. Is that correct?
Well, the deed, and again, this also is critically important, the deed that Boston Private gave to the trust, which does appear in the record at pages 129 to 131 of volume 1, it says it is conveyed subject to the extent applicable. The property is conveyed to the trust subject to the covenant. Now, as we've explained in our brief, as a matter of law, the covenant was no longer applicable because it was extinguished when the memorandum of sale was signed.
No, it wasn't extinguished. Well, it wasn't extinguished when the memorandum of sale. Are you saying that anytime, as soon as the foreclosure, the memorandum of sale was signed, it was considered a foreclosed property, but not to the bank, right?
Your Honor, the bank acquired title. The bank acquired fee simple title to the property the moment the memorandum of sale was signed. That is what Ibanez says. And in fact, that is entirely consistent with the language of Chapter 183, Section 21.
So he could have kept the property, not given it to the son, not put it in a trust, and he was not subject to the covenant. Is that
correct, Your Honor? Yes, I'm saying any foreclosure, in this case, in any foreclosure to anyone, even if as soon as it went to auction, yes, the covenant was extinguished. Even if the purchaser at auction had been a moderate income purchaser, because the BRA allowed the property, didn't exercise its own option to purchase the property directly from the estate. As soon as the property went to auction, the covenant was extinguished and would have been extinguished regardless of who the purchaser was or would have been.
You're disagreeing with Attorney Collier's response when I asked if the bank had gone to the second highest bidder, that the covenant and memorandum of sale would have executed. the second highest bidder would be subject to the covenant. You disagree with that. You're saying anytime any one of those bidders would have purchased the property, signed a memorandum of sale, and took the property, because at that point it was a foreclosure, fee simple had gone to the bank, and the bank then had the right to give it free of the covenant to any one of those bidders. I mean, not any one, but in the succession.
Correct, Your Honor. And it's not a question of the bank's right. It's a question of applying the law. When in the course of the foreclosure process, does title vest in the former mortgagee such that this covenant is extinguished in accordance with its plain language? Any conveyance to any purchaser in any auction would have eliminated this covenant. Yes, and that is consistent with, if you look at Chapter 183, Section 21, it says, at the beginning of any foreclosure auction, we know from Ibanez and Bevilacqua that we have a title theory state. Title to any mortgaged property is split between the mortgagee, the lender, which has legal title, and the mortgagor, which has equitable title, the equity of redemption. That's the state of play at the start of any auction. 183.21 says that at the end, after an auction, what the bank conveys to the purchaser or purchasers is fee simple title. It's right in the statute. The bank cannot convey fee simple title unless it has first acquired fee simple title. So in every foreclosure that happens in Massachusetts, every single one that goes to auction, the bank acquires fee simple title. Fee simple title must,
Your
as a
brother
matter
is
of past
saying that you violated the power of sale because rather than selling to the highest bidder or the next highest bidder, as was, I guess, the term of the power of sale is his theory, you instead conveyed to somebody else.
But Your Honor, that is the argument. That argument is betrayed by the allegations of the complaint itself. The complaint
So
says
you wouldn't, let's say you did actually convey to somebody unrelated to the highest bidder or who wasn't the assignee of the highest bidder, you could not have done that. Do you concede that? Even though the bank had fee simple title at the signing of the memorandum, you couldn't then go and, after the highest bidder backed out, sell to some random third party.
Well, Your Honor, I would say first the duty of good faith and reasonable diligence, as you yourself noted a couple of years ago in the Citadel Realty case, that boils down to an obligation to take the steps necessary to get the best price for the property as is reasonably attainable under the circumstances. So the bank did that here. Now, I don't know, and I have to answer Justice Wendlandt's question first, but yes, of course.
Go ahead. No, go ahead, finish.
And so to answer her question, I think what is required first and foremost is to get the best price. I don't know that the identity of the purchaser is essential, but in this case, it's not an issue because we did convey to the by the BRA's own allegations to the nominee of the assignee of the high bidder for the amount of the high bid. So we did everything right. Chapter 183, Section 21 was complied with, as were all the statutory and contractual prerequisites to foreclose, strictly, scrupulously complied with. The duty of good faith and reasonable diligence was complied with. Everything was done properly here. And I'm sorry, Justice Maldonado, you had a question.
Okay. So I know you're saying that the bank is under an obligation to get the best price when there's a foreclosure, and that's absolutely correct. But the best price in this scenario also includes that the property had this covenant. So it cannot be a built-in incentive for someone to actually foreclose because you're going to get a better price and buyer at foreclosure than you would if you sold it on your own. So the best price here had to also contemplate this idea that this property somehow has a sort of, not a defect, I wouldn't say that, but has a condition on it that actually would cause the price to be a little bit lower. And the purchaser, the mortgager understood that. I'm purchasing this property with a covenant. I understand that its fair market value is not what Charlestown's fair market value would be at 2000 something, but more what it would be under these conditions. So the best price here has to contemplate that, doesn't it?
Well, a buyer, a buyer, certainly in this case, was aware that, and certainly became aware that the BRA was going to assert its rights under the covenant, that it has no rights to assert. The covenant was extinguished, but the existence of the covenant in the first instance may well have resulted in that may well go into a bidder's determination of how much to bid at an auction. Again, here, any auction, execution of any memorandum of sale will, as a matter of law, extinguish that covenant, but Boston Private doesn't give legal advice to bidders, nor should it at any foreclosure auction. But yeah, what will the best price be in the circumstances? There's no allegation that, if anything, they claim we sold for too much money. There's no question, but that the bank did the right thing and got the best available price under the circumstances for this property. So again, for all these reasons, for all the reasons in Boston Private's brief, and most importantly, for the reasons in Judge Kaplan's very thorough and thoughtful memorandum of decision and order below, the judgment of the Superior Court should be affirmed.
Could I ask just one question before we wrap up, Justice Maldonado, with Attorney Riley's time? Mr. Riley, if it's the case, as you have argued, that fee simple transferred over on the signing of the memorandum, am I understanding correctly that that's your argument?
Oh, yes, and because that's what the SJC says, yes.
So what was the purpose then of going through the step of recording the deed and then reconveying by a separate deed?
Your Honor, as Judge Kaplan found, that was probably an unnecessary step on the part of Boston Private, but it was an utterly innocuous step. The recording of the deed from Boston Private to itself in January 24th did not affect the covenant. It didn't convey title. All of that happened under Bevilacqua, under Outpost, under Williams, when the memorandum of sale was signed. In Bevilacqua, the SJC specifically says, this is a 460 Massachusetts, page 771, that the recording of a deed is a purely ministerial action that has no independent legal significance. So the Boston Private's recording of the deed from itself to itself did nothing but provide notice to the world of the legal reality that had existed ever since December 6, 2017. That is that Boston Private already had fee simple title to the premises. So it is the recording of the deed has by Boston Private in January has no bearing on the outcome of this case at all. And there's a very thorough colloquy with Judge Kaplan that's in the appendix from the hearing below. But that is a non-issue, a non-factor in this case.
Any other questions? Okay, hearing none, we'll turn to Attorney Menekes.
Thank you, Your Honor. May it please the court, Jason Menekes on behalf of Ms. Blake in her capacity as trustee. I've obviously joined Attorney Riley's argument. I'll try not to be repetitive. There are just a few points I'd like to make that I think are important based on the questions without being redundant. The first one is that the covenant we're discussing has a dual focus, and I think it's very important to keep that in mind. The first one is that there's an affordability covenant. So if there's an impending foreclosure, the BRA has every opportunity to step in to pay the mortgage amount or the maximum resale price to the owner and to essentially save the property, take title to the property, preserve the covenant, or do whatever it would like with respect to future covenants on the property. That's the first focus. They didn't do that in this case for whatever reason. However, as Attorney Collier said at the outset, there is a mortgage. It is in the record. It is subordinate to Boston Private's mortgage, and therefore they have a choice. They can either buy it and save the covenant, or they can allow it to go at auction, potentially for more money, which happened in this case. To the extent that the bank sold it for significantly more money here, that money will be interpled and then go to the junior lien holders, the first one being the BRA. So when the BRA talks about in its papers preventing the monetization of these subsidies, it's actually the one who would get that monetization, meaning the extra equity. So I think that's important to keep in mind. I believe Justice Wendlandt asked a question about the duty that Boston Private might have to the BRA. I personally believe that there is a duty. I believe that, as Attorney Collier said, there's a duty to all junior lien holders, one of whom is the BRA, which has a mortgage in second position. The duty is not to preserve the BRA's covenant. That would run afoul of its duties. It couldn't try to preserve the covenant and sell it presumably to an affordable owner for less money, while at the same time fetching the highest price, which case law is clear is its obligation. So the dual focus of the covenant and the mortgage and the duties of Boston Private.
So,
yes, Your Honor.
Boston Private Bank have sold it to another higher bidder that was not your client?
I believe the answer is yes, with one condition. That condition is that Dundas and other cases talked about a prompt resale. And I think that the Attorney General mentioned in its brief that if they sold
yeah,
it for...
so that you've identified the nut. Better question, actually. Does that prompt resale need to occur at the auction, which did not happen here?
I don't believe it does, Your Honor, because there's a prevailing duty in all of those cases that talk about prompt resale. And some of them, it happens within 3 hours and some of them within a day. Some of them say it's fine and some of them say it isn't because of passage of time or because bidders dispersed. But in all of them where it was struck down as not being prompt, they're not looking at strict compliance with the power of sale. What they're doing is they're focusing on the duty of good faith. So in other words, in one of the cases, the bid was $41,000, everyone dispersed and they sold it for a fraction of that. And the court said, you can't do that. Why? Because you got a substantially lower price, as the Attorney General said, which didn't happen here. This is unique. And when Attorney Collier, I believe in the BRA's reply brief in one of the footnotes comments, well, they could have then sold it to their cousin for anything or the lowest bidder. The answer is, if we had done that, if we had sold it or the bank had sold it to a third party, not my client, for a substantially lower price or to their cousin
My
as a
question
favor.
is, could the bank have sold it to a third party for the same or higher price?
I believe they could. If they sold it for a lower price, they would violate the duty and the BRA could
But
claim
the
it's
higher price
voidable.
would be okay. You're saying that once the bank acquires title, it can sell it to anybody without redoing a public auction, so long as the price is higher?
Yes, as long as they comply with their duty of good faith to fetch the highest price, I believe they can. They could also, yes, I believe they can, Your Honor.
Do they need to do that by instituting a new auction?
I don't believe they do, Your Honor. As Attorney Collier said, the facts in this case are different and that the allegation is the assignee of the high bidder took it. But if they had sold it within this window for the same or a higher price and agreed as they did here to interplead that fund for the benefit of junior lien holders, then I don't believe they violated that duty to fetch the highest price. I see I'm out of time. I'm happy to answer further questions, but thank you, Your Honor.
Okay, I see no other questions. The case is submitted. Very well argued.